No humans were harmed or even used in the creation of this program. We created it from a script written by the presenter using a generative artificial intelligence platform. We hope you enjoy it. Welcome to today's program, Negotiation Ethics for Lawyers and Introduction. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I am speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Our subject today is one of my favorites. What are the legal ethics rules that apply to lawyers when we negotiate? This is an introductory course, but by no means is it rudimentary. We'll tackle some difficult questions as we explore how the legal ethics rules seem to bend, and some would argue break, when lawyers are negotiating on behalf of their clients. While it's easy to recite the rule that it's unethical for a lawyer knowingly to make a false statement of material fact to a third person, it's harder to apply that rule in the context of a negotiation to settle personal injury claims when the plaintiff's lawyer, as everyone expects that she would, talks up the severity of her client's injuries in an effort to obtain a larger settlement for her client, or on the flip side, when the lawyer for the insurance company downplays the severity of those same injuries. When you saw that today's topic is negotiation ethics for lawyers, what was your reaction? In my experience, the most common reaction practicing lawyers have is to roll their eyes and say something like, "Well, that sounds like an oxymoron." They might follow up with some other skeptical questions like, "Is there any such thing as ethics in negotiation? If there were such a thing as ethics in negotiation, are there any rules? And if there are any rules, does anyone even know what they are? And finally, if people did know what the rules are, would they bother following them?" It's fair to say there's a healthy bit of cynicism about negotiation ethics as a topic, and I certainly recognize that. My goal today is to convince you that there in fact are rules, and they can be articulated, understood, and applied in a variety of contexts that will help you figure out where the ethical lines are and make sure that you always stay on the right side of them. I guess I'll find out in your evaluations whether I've succeeded or failed. But that is my mission today. This introductory program is the first program in our Negotiation Ethics for Lawyers series. If you enjoy it and would like to view more programs in this area, we have quite a few more to offer you, and those additional programs most likely are available on the same service where you are watching this one. Our second program, How to Recognize and Respond to Dirty Tricks and Bad Faith Tactics, examines several common negotiation dirty tricks that the other side might attempt to use against you and focuses on how you should respond without violating your own ethical obligations. Our third program follows the same approach, but focuses on the sorts of dirty tricks and bad faith tactics that the most sophisticated parties might employ in their efforts to obtain an unfair advantage in their negotiations with you. You can think of it as a more advanced version of our second program, a master class in negotiation ethics and strategy, if you will. Our next two programs are probably the most fun because we look at how negotiations are portrayed in two amazing Hollywood films, and we take lessons from those negotiations that can be applied to real-world negotiations that you might have in your legal practice. Our sixth program discusses paltering, which is defined as the active use of selective, truthful statements to mislead as a negotiation tactic, and considers whether paltering by lawyers violates the legal ethics rules. Finally, in our latest program, we return to our roots and analyze even more dirty tricks that the other side may try to use against you in your next negotiation, and how you legally, ethically, and strategically can respond to those tactics. I also should mention that for California lawyers, who are now required to complete 1 hour of civility in the legal profession CLE credit, we have a program entitled Civility. Do lawyers have a duty to negotiate in good faith? That is an honorary member of our Negotiation Ethics for Lawyers series because it discusses whether California's non-binding civility guidelines impose a duty on lawyers to negotiate in good faith. As you might expect from our robust offering of programs in this area, negotiation ethics is a popular topic. I think that is so because not only are lawyers looking for guidance on how to make sure they comply with their legal ethics obligations when they negotiate, but also because they feel that they need help in terms of knowing how best to respond when they believe that the other side is acting unethically. If that describes you, then you've come to the right place, and I hope you take advantage of this program and the other programs that we have available in our Negotiation Ethics for Lawyers series. My favorite way to introduce the topic of negotiation ethics for lawyers is to begin with a very famous, indeed a classic negotiation scenario, the case of Teddy Roosevelt. Our story begins back in 1912 with then presidential candidate Theodore Roosevelt, whose campaign found itself in a seemingly impossible negotiating position. Teddy was nearing the end of his campaign with a final whistle-stop tour through the heartland of the country. At each stop, he planned to give one of his famous bully speeches and distribute to the audience a small pamphlet with a copy of the speech on one side and a picture of his famous mug on the other side. The campaign believed this strategy would propel them to victory. There was just one small problem with the pamphlet, and before I tell you the problem, I should tell you that the campaign already had printed 3 million copies of the pamphlets, which were sitting in a rail car ready to be distributed. When the campaign finally looked carefully at the photograph of Roosevelt they had used on the pamphlet, they saw a line at the bottom that read, "Copyright Moffett Studios, Chicago." The sudden realization that they didn't own the copyright to the photograph they had used sent the campaign into a tizzy. It appeared to them that they had two options, neither of which was very good. One option was to ignore the copyright notice and use the photograph without permission from Moffett Studios. This option risked being sued and potentially paying statutory copyright damages, which at the time was $1 for each infringing work, so potentially $3 million in damages. This was on top of the public relations risk if they were found out to have used the photograph without permission, in essence being branded scofflaws who don't observe copyright laws. The second option was to negotiate a license with Moffett to use the photograph, and to do so from what seemed to be a hopelessly weak bargaining position, not only because they already had printed the pamphlets, but perhaps more importantly, because they didn't have time to print 3 million more pamphlets that used another photograph. In most negotiations, your leverage depends in large part on the availability of your alternatives to making a deal with the party with whom you are negotiating, and it seemed that the campaign's only viable alternative was to negotiate a license from Moffett, and to do so very quickly. Fortunately for Roosevelt, his campaign manager happened to be noted financier George Perkins. Perkins quickly crafted and sent a telegram to Moffett Studios, which read as follows: "We are planning to distribute many pamphlets with Roosevelt's picture on the cover. It will be great publicity for the studio whose photograph we use. How much will you pay us to use yours? Respond immediately." The telegram said, "Respond immediately," and for better or worse, that's exactly what Moffett did. Moffett's response was, "Never done before, but under the circumstances, pleased to offer $250. What is your reaction to this famous negotiation? The first reaction of most people is something like, "Wow, how incredibly clever. What an amazing thing this guy George Perkins did to get his campaign out of an incredibly difficult spot." Most folks then have a second reaction, which is to question whether Perkins acted appropriately. Did Perkins lie to Moffett? If he didn't lie, did Perkins nonetheless have any obligation to inform Moffett of the relevant facts? I think we all can agree that Perkins's telegram at a minimum was deceptive, and also that Moffett clearly was deceived based on the response he gave. But is there anything wrong with being deceptive in a negotiation as long as you don't actually lie? Would your answer change if Perkins had been a lawyer and was subject to the legal ethics rules, in addition to the rules that govern all of us in our business dealings, such as the law of fraud? These are the sorts of questions we are going to explore in our program today. As we will do with all of the examples we'll discuss, let's start by looking carefully at each of the statements Perkins made in his telegram. The first statement is, "We are planning to distribute many pamphlets with Roosevelt's picture on the cover," is literally true. The campaign is planning to distribute the pamphlets with Roosevelt's picture. Of course, by making this statement, Perkins is implying falsely that the campaign is in no rush. We are planning to distribute, as if the distribution were to occur some days or even weeks from now. People likely will disagree whether it is appropriate in a negotiation to make literally true statements that are intended to mislead the other party, and we'll examine later whether such statements when made by lawyers are allowed under the legal ethics rules. For now, it's enough to recognize the distinction between a statement that is false and a statement that is literally true but misleading, as that distinction is an important one. The other question that this first statement raises is whether Perkins had any obligation to tell Moffat that the campaign already had printed the pamphlets. On this point, there is a fairly broad consensus that in a negotiation, you don't have any obligation to volunteer information that suggests you are in a weak position. No matter what you think of Perkins's overall approach to Moffat, nearly everyone would agree that Perkins had no obligation to state in the telegram. By the way, we've already printed them up and don't have time to change the pamphlet. Let's look at the second statement in the telegram. It will be great publicity for the studio whose photograph we use. Is this statement a lie? No, and it's important to understand why not. First of all, it's a statement of opinion and not a statement of fact. It will be great publicity for the studio whose photograph we use is a statement of Perkins' opinion, not a statement of fact. While you certainly can lie about your opinion of something. For example, I think your new Hawaiian shirt looks terrific. We are primarily concerned with statements of fact when we are looking at the conduct of parties in negotiations. That said, when you are in a negotiation, it's important to recognize when something is being presented to you in the form of an opinion and not as a statement of fact. It could be that your counterparty is framing something as an opinion so as to avoid making a false statement of fact, or, as Perkins repeatedly did in this case, to mislead Moffat into thinking that the campaign has meaningful alternatives to using his photograph. It will be great publicity for the studio whose photograph we use. This is an opinion. It's probably literally true, as Perkins likely believes it will be great publicity for Moffat to have his photograph used in the pamphlet, and an opinion that is being offered primarily to mislead Moffat. It's also important to recognize that the statement relates to the campaign's alternatives to using Moffat's photograph. Because a party who has more and better alternatives generally has more leverage in a negotiation than a party who has fewer and worse alternatives, statements about those alternatives often are critically important in a negotiation. As we lawyers would say, material to the negotiation. Consequently, if you fabricate alternatives or falsely imply that you have many of them, you are likely to achieve a better result in the negotiation. That is one reason why the law of fraud, which creates a cause of action for false statements of material fact upon which the other party reasonably relies to his detriment, may allow victims of material false statements to recover damages or perhaps even to rescind a transaction that was obtained by fraud. As we will see a bit later, the legal ethics rules also prohibit lawyers from lying about their clients' alternatives, whether or not the other side reasonably relies on those statements or suffers damages. What about the third statement? How much will you pay us to use yours? What do you think about that one? Well, it's not a lie because it's not a statement of fact, but once again, it misleadingly suggests that the campaign has alternatives to using Moffat's photograph. Yours is the key word in that it suggests that the campaign has several alternative photographs that they're looking at. You might also question whether it was misleading for Perkins to suggest that Moffat should be paying the campaign to use the photograph, and not the other way around. I don't necessarily read it that way because in the realm of content licensing, it's not uncommon for deals to be struck for no payment at all, or for payment to flow differently than you might expect depending on the relative strengths of the content owner and the distributor. It's certainly clever for Perkins to frame the issue of payment in this way, and clearly it was highly effective. Let's look at the last sentence. Respond immediately. Clearly not a lie, but what is Perkins up to here? I think most of you will recognize that Perkins is attempting to put pressure on Moffat by insisting upon an immediate response. This is a common tactic in negotiations, and Perkins uses it to great effect here by essentially turning the tables on Moffat. Perkins is the one who is under extreme time pressure to make a deal with Moffat because they need to begin distributing the pamphlets right away, and yet he turns this around to give Moffat the impression that he must respond immediately with a compelling offer to beat out the competition and secure his photograph as the one the campaign will use. I think this statement falls into the category of a negotiation tactic, as opposed to a statement that you can say is false or even misleading, particularly given that Perkins, in fact, did need Moffat to reply very quickly. Too bad for Moffat that he did so. Another thing I love about the case of Teddy Roosevelt is that just as you might be tempted to say, how dated is this example? They're talking about sending each other telegrams for goodness sake. I trust you will realize, as I did when I first taught it to students, that this example is the same as negotiating by email, which happens all the time in modern business and legal practice. The key difference between negotiating in person or telephone and by email is that in the latter case, you can frame your statements very carefully, as Perkins clearly did here, and unless and until the email is followed up by a call, neither party will have the opportunity to ask questions of the other. Just imagine how this negotiation could have gone if Moffat had stopped to ask Perkins some questions such as, when you say that you're planning to distribute pamphlets, when do you plan to start? When you talk about the studio whose photograph will be used, who else has photographs that you are considering? Of course, there is the best and most direct question if Moffat had been clever enough to think of it. Have you printed the pamphlets yet? If Perkins had said in reply, no, we haven't printed them, then you've got an overt lie that could make out a case for fraud. Or if instead Perkins had replied, yes, we have printed them. That obviously flips the leverage around. Any of these questions would have put Perkins in the uncomfortable position either of having to lie to keep the charade alive or to give up the ghost, effectively paving the way for Moffat to name his price to use his photograph. Another key takeaway from the Roosevelt example is that the ability to ask questions and the ability to stop yourself from making assumptions in a negotiation in favor of asking questions to confirm every fact you believe to be true and upon which you intend to rely are some of the main tools you have as a negotiator to ensure that you are not being deceived by the other side. Asking questions is also useful because it gives you an opportunity to find out what interests lie behind the positions the other party is taking in the negotiation in order to identify opportunities for mutual gain. The classic example is if I want an orange and you want the same orange, we could negotiate to split it 50-50 or 60-40 or whatever we settle on. But if I ask you why you want the orange and you say to eat it, and you ask me why I want the orange and I say I only need the peel for making cocktails, we both can get 100% of what we want. How many real-world negotiations are over oranges? 0. How many of them are that simple? 0. But the point here is don't assume that what you're trying to get out of a transaction is the same as what the other side is trying to get. And when those things end up being different, now you have an opportunity, and that's really worth exploring. Real-world negotiations are never easy to optimize, but I trust you can see why identifying interests that lie behind positions is a good way to negotiate and can leave both sides better off if done well. We've been through each of the statements Perkins made, and we can't find any false statements of fact. Of course, that's precisely why this is such a famous example. Perkins was able to mislead Moffat and obtain a spectacular result for the campaign in a situation that appeared hopeless without telling even one lie. But I think everyone will agree that Perkins's statements, taken separately and especially when considered together, were highly misleading and also that Moffat was misled. Is there anything wrong with intentionally misleading the other party in a negotiation? This is where opinions tend to diverge, not just among lawyers, but among everyone who negotiates. Some folks think it's perfectly okay to mislead the other side as long as you don't lie, while others think it's not okay to mislead the other party, or at least that it's not okay to mislead the other party too much. Sometimes you'll hear a party who intentionally misleads the other side in a negotiation described as someone who is negotiating in bad faith. This suggests people have a duty to negotiate in good faith, and assumes that such a duty would prohibit people from making statements that are intentionally misleading, in addition to prohibiting outright lying. But is there a duty to negotiate in good faith? The short answer is no. The longer answer is that in general, in the United States, there is no independent duty to negotiate in good faith, because neither the law nor the legal ethics rules require the parties to negotiate in good faith. We do need to distinguish a few things. If you're under a contractual duty to negotiate, let's say you have a first negotiation provision in a contract or a duty to negotiate an extension, The law would imply a duty of good faith in the performance of that contractual obligation. As we all remember from first-year contracts, the law implies a duty to perform all contractual obligations in good faith, which then would include contractual duties to negotiate in cases where such a duty is part of the contract. But that's a specific case, and absent that, there is no general duty to negotiate in good faith. Now that said, there are two caveats to this. The first caveat is that we're talking here about United States law and law in the various 50 states. In some European jurisdictions and in China, for example, there can be a general duty to negotiate in good faith. The second caveat is there are some aspirational guidelines, including some published in California, about civility that do suggest that lawyers should act in good faith when they are negotiating. But that is not something that's strictly speaking binding on lawyers. The ethics rules, as we'll see in a second, plus judicial decisions are the things that bind lawyers, not these aspirational guidelines. But there are some aspirational guidelines out there, most notably in California, that do suggest that lawyers should negotiate in good faith. Setting those caveats aside, the fact that there is no general duty to negotiate in good faith is a point that's very often misunderstood among lawyers and even some judges. Lawyers often levy charges against one another of negotiating in bad faith, but usually they're just describing some conduct that they don't like, or that they find takes a sharp edge, and it's not really talking about a violation of some independent duty to negotiate in good faith. There is no independent duty absent a contractual obligation to do that in the United States. Finally, while it's fair to say that there's no one watching this who would receive an email today and respond with an acceptance, or perhaps even a counter, I think it's much more likely that they pick up the phone and say, "You need to help me understand what you mean by this." The case of Teddy Roosevelt is obviously an example of clever negotiating, but it's also an example of several statements, each one of which can be defended on a word-by-word or sentence-by-sentence basis, but which overall creates a false impression and really meaningfully changes the leverage in the negotiation to the detriment of Moffat. While I would give Perkins kudos for being clever, I don't think you'd want to be in the position of the Roosevelt campaign having to defend his actions to the public if they ever came to light. You should keep in mind that your professional reputation and the reputation of your clients are two very important things that you want to safeguard when you are negotiating, whether or not your conduct is prohibited by the law of fraud or the legal ethics rules. Let's switch gears and begin to take a look at what the legal ethics rules have to say about a lawyer's ethical duties when he or she is negotiating on behalf of a client. To help us illustrate and apply the ethics rules, we are going to use a fun hypothetical and one that is near and dear to everyone's heart, at least here in Los Angeles, and that is the idea of selling a screenplay. I guess people will deny working on one, but we're going to use an example of a former Santa Monica Mafia kingpin whose name is Dominic Vitello, and he would like for the world to know his life story. He's going to sell a screenplay that he's written about his life to the highest bidder. In this hypothetical, we're talking about a deal between two parties, Vitello on the one hand, and a company that we're going to call Shady Studios on the other. Vitello's agent, who's named Ari Silver, is negotiating with Shady Studios attorney Mallory Hinton. And it's important to note here that both Silver and Hinton are industry veterans, and we'll see later that that's going to be important in framing what their reasonable expectations are of one another. There's another point here that we will touch on later, and that has to do with what role these people are playing. We have an agent and we have an attorney, and people often ask the question whether the agent and/or the attorney are functioning as attorneys in negotiating this deal, or whether they're really functioning as business people. We'll see later that it may make a difference in terms of whether the ethical rules travel with them as they're engaging in this negotiation, whether they're acting as business people or as attorneys. But we'll just take it as a given for now that they're acting as attorneys in the course and scope of the representation of their respective clients, and that the ethical rules do in fact govern their conduct. Before we dive into the rules, let's take a look at the first scene from our hypothetical to give you a feel for where the rubber meets the road in real-world negotiations.
Hi Mallory, Ari Silver here. I wanted to see if you want in on the action for Dom Vitello's script. It's a hell of a story. Now my client is only interested in negotiating a deal if Shady Studios agrees that he has final say on which actor portrays him in the film.
Ari, not a problem. Shady Studios will work with your client to make sure he's completely satisfied.
The ethical issue here is when Mallory responds, not a problem. It suggests that she's agreeing with what Ari is saying, and specifically, his demand that his client have final say over who plays him in the movie, when Mallory knows that Shady Studios has no intention of agreeing to that. There is a very clear ethical issue with her response, and we're going to talk in more detail about how the ethics rules would speak to that and how you should analyze it. Let's take a look at the second scene.
Mallory, you realize we could sell the script to any studio in town. It's got sex, violence, and a true story. You might as well start the Oscar campaign now. Every major player in Hollywood has already expressed an interest in my client's story. In fact, I've got 3 meetings today, so is Shady Studios in the game or not?
The ethical issue here is that the few studios that Silver's actually spoken with have expressed lukewarm interest at best. And by the way, the 3 meetings happen to be with his kid's teacher, with a stockbroker, and with his manicurist. This response raises ethical concerns too, but it's less cut and dried than the first scene. Again, we'll analyze this scene in detail after we've covered the relevant ethics rules. Turning now to the legal ethics rules, the place to start is with the ABA model rules, which are now followed by the vast majority of states, including California and New York, and specifically ABA Model Rule 1.3. Model Rule 1.3 provides that a lawyer shall act with reasonable diligence and promptness in representing a client. This is pretty familiar, I'm sure, to most viewers, if not all. This is the duty of zealous advocacy, the thing that we all learned in law school, the thing that is a heightened duty for criminal lawyers, but generally for all lawyers, you do have a duty to represent your client zealously within the bounds of the law. What I'd like to focus on also is in the comment to this rule that makes it clear that while a lawyer must act with commitment and dedication to the interest of the client and with zeal and advocacy on the client's behalf, a lawyer is not bound to press for every advantage that might be realized for a client. The way I like to think of this rule is, there's a general duty of zealous advocacy that we all operate under, and those of us who practice civil law, it's not that heightened duty in criminal cases, but you want to represent your client zealously. What that really means in the context of a business transaction or negotiation is that you're not obligated to crush the other side. You don't have to force them into submission. You can be reasonable and you can negotiate for those things that are most important to your client, and you don't have to get absolutely every last penny off the table. That's how I look at that rule. A nice companion to Rule 1.3 is ABA Model Rule 2.1, which sadly doesn't get that much attention, even though it has been around as long as many of the other rules we will discuss today. Rule 2.1 talks about the role of morality in advising clients. There's a specific section that says that a lawyer may, not must, but may advise a client with respect to morality. We can imagine an opportunity that a lawyer might have to engage in sharp practice where they, instead of feeling obligated to engage in that conduct, had a discussion with the client and explained why something might be technically within the law and ethical rules, but implicate notions of fairness and justness and morality. That's certainly fair game, and it's the kind of thing that hopefully lawyers are talking to their clients about, as opposed to setting an example for really the most aggressive or egregious conduct in negotiations. I will confess to being hard on lawyers when I discuss negotiation ethics, but it bears mentioning one other thing that goes on in the real world. Your client presses you to take a very extreme position. Often you're in a spot where you're negotiating not only with the other side but with your client about why taking a dodgy position or sharp edge, something that's arguably crossing the line, isn't really in the client's interest. I think a lot of that's going on, and we're focusing on a hypothetical where it seems like this is coming from the lawyer, but it could very easily be coming from the lawyer's client saying, "You've got to go out there and get me the $4 million for my script that I want. I don't care what you have to do it. You're my lawyer, you need to be zealous and advocate for me." I think there's a lot to this. We may have more or less control over our client depending on the situation, but Rule 2.1 does give us cover under the ethics rules to attempt to persuade a client not to take an amoral position. You should use it when needed. "I was only following my client's instructions" is not a defense to a legal ethics violation. nor is it salve for a badly injured professional reputation. The next rule to focus on is ABA Model Rule 8.4, which provides that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. The way I think of this is, in being a zealous advocate, you're not allowed to lie, which is to say you're not allowed to make a false statement of material fact. You're not allowed to commit fraud, you're not allowed to commit deceit, you're not allowed to misrepresent. This is very important, and lawyers need to know that if you are engaging in this conduct when you negotiate, lying, misrepresenting facts, being deceitful, you are violating the legal ethics rules and could subject yourself to discipline. You also could open up your client to an action for fraud. This is a good place to make a distinction between the ethics rules and a cause of action for fraud or for misrepresentation or deceit. We're going to talk and look at these hypotheticals and analyze them to see, okay, have you arguably violated your ethical duties, and what might be the remedy for that? One other thing to worry about is a possible cause of action for fraud. If you've committed an act in a negotiation, whether it's an ethical violation or it isn't, the other side could sue your client for fraud. They could make a claim that you've made a false statement, that it was material, that they relied upon it to their detriment, and that they've suffered damages. Because there's always the possibility that the other side could bring a fraud claim based upon your conduct in a negotiation, I would urge you to follow the guidance that I'm presenting to you today. Another important thing you should be concerned about if you lie, misrepresent facts, or act deceitfully in negotiations is your reputation. You're going to be dealing with a lot of the same people in your practice over and over again. I work in Los Angeles, and you might think, well, that's a huge metropolitan area. I'm sure there's hundreds of thousands of lawyers. But in reality, it's a pretty small community when you are talking about the entertainment industry. It's rare that I deal with somebody that I don't know or where I don't know someone who knows that person. And if you get a reputation in your community for sharp practice, that could really be a detriment to you and to the clients you represent. Let me explain what I mean. If I'm negotiating with someone who I know has a reputation for sharp practice, I'm going to be extra careful with that person. There might be reasonable accommodations that I would make for people that I deal with regularly who I feel are straight shooters. With some of those folks, I could get a deal done in a day and feel comfortable relying on an email confirmation even before the contract is done because I know and trust them. If I don't trust you, I will make you document every statement you make to me that I can't independently verify before I will rely upon it, and that process can take a very long time. I'll also likely take a harder line against you if I believe you are a shady negotiator, because I expect you will be doing the same in your dealings with me. If this type of negotiation takes longer than your client wants and ends up delivering less value to your client than another lawyer could have obtained, you will end up being less effective for your client precisely because you have a reputation for sharp practice. Our next stop is a critical rule for lawyer negotiators. ABA Model Rule 4.1. This is a rule that we will come back to again and again. Here is what the rule says. In the course of representing a client, a lawyer shall not knowingly A. Make a false statement of material fact or law to a third person, or B. Fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6. The language starts, in the course of representing a client, a lawyer shall not knowingly. Then we have a couple of examples of things that the lawyers may not do. Let's look closely at this clause because each of the words turns out to be quite important. First of all, it starts off with, in the course of representing a client. Someone whose conduct has been challenged, if they are a lawyer, they are very likely to go back to the beginning and say, wait a minute, this was not in the course of representing a client. I may be an attorney, I may pay my bar dues, I may be listed on the bar website, but I am a business person. I am somebody who functions as a lawyer most of the time, but in this context I was merely negotiating. I'm just a regular business person, so therefore the rules of ethics don't travel with me. While you could attempt to make this argument, it's very dangerous for lawyers to pick and choose when they're functioning as a lawyer and when they're functioning as a business person. Sometimes this issue comes up in the context of what types of communications may be privileged. Unfortunately, for the lawyers who are picking and choosing their moments, The same lawyers that are wanting to claim that their communications are privileged and can't be discovered, say in litigation, may be the same ones who want to say that they're not governed by the rules of ethics. In general, if you're an attorney and you are negotiating on behalf of a client, that's a pretty standard role that attorneys play on behalf of clients, and you should assume that your conduct is going to be subject to the ethics rules. A lot of people also use this as an excuse to say, well, as a lawyer, I'm being limited in how well I can negotiate because unlike the person across the table who doesn't happen to be a lawyer, I'm subject to all the ethics rules, so doesn't that put me at a disadvantage? My considered view is that at the end of the day, even though we are acting as lawyers and subject to these extra rules, these rules for the most part are really just good ideas. Anytime you're sliding across a line where you'd be in a situation that you'd be violating one of the ethics rules, you're putting your clients at risk of a fraud claim or yourself of getting a reputation for sharp practice that's ultimately not going to inure to your or your client's benefit. As a result, I don't buy into the argument that lawyers have one hand tied behind our backs when we negotiate because we have these extra rules that we must follow. The next keyword in Model Rule 4.1 is knowingly. The rule provides that a lawyer shall not knowingly make a false statement of material fact or law to a third person, in Section A, and then in Section B. Knowingly fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. If a lawyer did not know a statement of fact was false at the time he made it, that conduct would not violate Rule 4.1. The word material obviously is another potential escape hatch. Putting it all together, you can imagine a crafty lawyer arguing in the alternative something like, first of all, this was not in the course of representing a client. Second, they'll say, well, I did make a statement, but it wasn't knowingly false. It may have turned out to be false, so they'll hinge on that word knowingly. Then they'll say, third, sure it was a knowingly false statement, but it wasn't material. Of course, that always raises my favorite response, which is, if it wasn't material and you didn't think it was going to make any difference, then why did you bother to raise it and emphasize it and stress it? While you could make all of these arguments, Model Rule 4.1 actually sets out a pretty clear standard for lawyers to follow and gives us fair notice that we can face consequences if we fall short. As important as Model Rule 4.1 is, the comment is arguably more important because it is attempting to unravel what it means to not knowingly make false statements of material fact in the context of negotiations. The comment begins by observing that under generally accepted conventions in negotiation, certain types of statements ordinarily are not taken as statements of material fact. Estimates of price or value placed on the subject of a transaction and a party's intentions as to an acceptable settlement of a claim are ordinarily in this category, and so is the existence of an undisclosed principal except where non-disclosure of the principal would constitute fraud. Let's look at each of these examples in turn. 1. Estimates of price or value. For example, hypothetically, the value of a script. This is a very valuable script. This script is worth $10 million. That would seem to be covered. 2. Intentions as to an acceptable settlement of a claim. We hear all the time, we have no intention of settling this case for less than $1 million. Third, the existence of an undisclosed principal. Think of a lawyer who is representing a developer who wants to buy up several parcels anonymously, which is a common practice in real estate. Think of Walt Disney buying several small farms in Anaheim so that he could build Disneyland, and not wanting any of the sellers to know that he needed all of their farms to complete his plans. If any farmer knew what Walt Disney was up to, the farmer would have a hold-up opportunity, and that is what Disney was looking to avoid. Because this practice is common in negotiations, the comment is saying that a lawyer doesn't violate Rule 4.1 by failing to disclose the existence of an undisclosed principal. People sometimes wonder when a lawyer's failure to disclose the existence of an undisclosed principal would constitute fraud, thus falling outside this exception and being actionable under Rule 4.1. Perhaps the best example is a lawyer who represents a borrower who has defaulted on a loan. The lender is now seeking to sell off the loan at a discounted price. If the borrower then asked his lawyer to represent him or an affiliated party in negotiations with the bank to purchase the loan and to conceal his identity from the bank in that process, The lawyer's failure to disclose the identity of her client in that case might constitute fraud. That is because the bank might not be willing and potentially might not be able under its internal rules or government regulations to sell the loan back to the original borrower. This makes the identity of the client a material fact that the lawyer cannot fail to disclose, consistent with the requirement of Rule 4.1. Another interesting point here is that unfortunately, I think the comment does a little bit to confuse readers because of how these exceptions are described. The comment identifies these types of statements as not being statements of material fact, so estimates of price, intentions as to an acceptable settlement, and undisclosed principal are not statements of material fact. It attempts to use that as the justification for not making them ethical violations. The problem is that these are statements of material fact, which makes the ABA's guidance confusing. It would have been better if the ABA had said, "These are statements of material fact. They're just not the types of things that we would expect a reasonable person on the other side to rely upon." Regardless of the justification, these are the types of conduct or statements that are going to be accepted from Model Rule 4.1's prohibition on making knowingly false statements of fact or law. The other key parts of the comment are the parts that make clear that a lawyer is required to be truthful when dealing with others on a client's behalf, but generally has no affirmative duty to inform an opposing party of relevant facts. The comments also clarifies both that a misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false, and that misrepresentations can also occur by partially true but misleading statements or omissions that are the equivalent of affirmative false statements. The first concept is straightforward. There is no obligation to tell the other side relevant facts in a negotiation. We've already seen this in the Roosevelt example where George Perkins had no obligation to disclose in his telegram to Moffett that they'd already printed the pamphlets or that they needed to begin distributing them right away. The next concept, that a misrepresentation can occur if the lawyer affirms a statement of another that the lawyer knows is false, is also sensible. In other words, if you adopt a false statement made by another person, that false statement will be attributed to you. Finally, the last concept is very important, but also trickier, and we'll come back to it quite a bit. Partially true but misleading statements or omissions can be the equivalent of an affirmative false statements. The idea here is that statements or omissions can be so misleading that they can be considered the same as outright lies. Again, we should be thinking of Perkins and his telegram filled with carefully crafted statements and omissions, but no outright lies. Of course, this last part of the comment opens Rule 4.1 up to interpretation and gray areas, but it's necessary to capture conduct, like the conduct of Perkins in the Roosevelt case, where you can't point to a single lie, but where there are one or more misleading statements or omissions that really should be considered the same as affirmative false statements. With the ABA model rules under our belt, let's go back to the first hypothetical and analyze it.
Hi Mallory, Ari Silver here. I wanted to see if you want in on the action for Dom Vitello's script. It's a hell of a story. Now my client is only interested in negotiating a deal if Shady Studios agrees that he has final say on which actor portrays him in the film.
Ari, not a problem. Shady Studios will work with your client to make sure he's completely satisfied.
Mallory's response is initially 2 sentences, and I think we should look at these sentences separately and then look at them together. The first sentence is not a problem, and I actually think that sentence is itself a problem. Certainly standing alone it would be a problem because it suggests agreement with what came before it. What came before it? The comment by Ari that his client was only interested in negotiating a deal if he has final say on which actor portrayed him. I think standing alone that would probably be found to be an agreement on that point. Here, you should be thinking about Model Rule 4.1 and the comment that made clear that a misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. If this was the only statement Mallory made, I think you could make a good case that she adopted Ari's statement, and that statement is false because Shady Studios has no intention of letting Vitello decide who plays him in the film. What's interesting is that the first sentence is followed immediately by a second sentence, and the second sentence is quite generic. Shady Studios will work with your client to make sure he's completely satisfied. At first, it sounds like a throwaway sentence because it's a prediction of future events or a statement of intention. It's not really a statement of fact, much less a statement of material fact, but when it's coupled with the first sentence, you have to wonder whether or not it saves the first sentence, which was, not a problem. In other words, the second sentence makes it sound like Mallory isn't actually adopting Ari's statement as her own, but rather is saying something very generic, that is more a prediction of future events and not an agreement to Ari's condition that Vitello will get to decide who plays him in the film. On balance, I think this is a close call, but probably not an ethical violation for the reasons we just discussed. I think this is really a lesson where context matters. I mean, one sentence by itself, probably a problem. Two sentences together, when read together, might save what otherwise would be an ethical violation. Even if she didn't violate the ethical rules, I do think Mallory's conduct creates a potential problem for her in that she's going to get a reputation for being dishonest. That could make it more difficult for her to get deals done in the future, as counterparties will come to believe that they can't trust her, and she might be less effective for shady studios as a result. Let's take a look again at the second hypothetical.
Mallory, you realize we could sell the script to any studio in town. It's got sex, violence, and a true story. You might as well start the Oscar campaign now. Every major player in Hollywood has already expressed an interest in my client's story. In fact, I've got 3 meetings today, so is Shady Studios in the game or not?
In this hypothetical, we had Ari begin by saying, "You realize we could sell this script to any studio in town." Let's focus on that first sentence. It's not a false statement about a past fact, it's a prediction about future events, and I don't think you could say it's false or impossible. It's certainly true that they could sell to any studio in the city. I think that sentence standing alone isn't a false statement of a material fact. The next 2 sentences are fillers, a mix of true statements and opinions that we can skip over them. The fourth sentence where he says, "Every major player in Hollywood has already expressed an interest in my client's story." That's a different matter. Here he is making a statement of fact. He's saying, every major player in Hollywood has already expressed interest. So a clear statement of fact, something that is supposed to have happened in the past, and it's clearly false as we saw from the rest of the setup. It gives this impression of a strong alternative, and we previewed earlier. Your leverage in a negotiation almost in every case turns on what are your alternatives. If you and I don't make a deal, what am I going to do? What is my alternative? And in negotiation theory, that's often called your BATNA, which stands for Best Alternative to Negotiated Agreement. If the hypothetical is making a deal with Shady Studios, the alternative would be making a deal with Paramount or making a deal with Universal. That's the concept. And here by saying every major player in Hollywood already has expressed interest in his client's script, he's giving the false impression of a strong BATNA in an effort to improve his negotiating position. I think, again, context does matter. In the same breath that I say that statement is a problem, you might be tempted to respond, well, in this context, what do you expect an agent to say? I mean, an agent is going to come to you and wants you to buy his client's script, and of course, he's going to say everyone in Hollywood is begging for this thing. So it may well be that even something that's a technical violation, and we've just analyzed it and made a good case for why it is a violation of the ethics rules, you might say in this context. I'm never going to believe an agent when he tells me that a script is being sought after by everyone. That's a fair point, and it could help to save Ari from an ethical violation. Like an estimate of price or value, if Ari's false statements are not generally viewed as statements of material fact in this context, he could escape liability under Model Rule 4.1. For the same reason, Ari might also escape liability on a fraud claim if it were based solely on his false statement of interest by other studios. If you tried to make out a fraud claim on this separate from the ethics rules, you'd have to show reasonable reliance and damages. Here, you could make an argument that if Mallory and Ari deal with each other regularly, and we said in the hypothetical that they are repeat players in the industry, and the studio lawyer who's used to buying scripts, and agents who are used to selling scripts and puffing up interest and saying, hey, this is a hot property. The fact that Ari chose to say, every major player has already expressed interest, if Mallory doesn't really hear that as, oh wow, actually he's talked to these studios, it may be, okay, he's just puffing. He's just saying, this is a hot property. We've got to move on it quickly. It's possible that might save what is otherwise a statement that I think could be problematic, but I think you can see how a statement about past events that's clearly false and material raises an ethical concern. A good way to separate our thinking on this is that the statement, every major player in Hollywood has already expressed an interest in my client's story, if that is a false statement of material fact, you very well may have an ethical violation because the ethical violation or the ethical rules do not require the additional elements that you have with the civil fraud claim. You're not required to show reasonable reliance. You're not required to show damages. So the fact that one might not reasonably rely upon that may well save the lawyer from a fraud claim for damages, but I don't believe that, at least as a technical matter, it excuses the ethical violation. Let's turn to the last sentence about Ari having 3 meetings today, and we learned that those meetings were not with other studios, but they were personal meetings related to him or his kids. It's clearly not false. He did in fact have those meetings, but he mentioned them to give the impression that he had business meetings related to this project. It's not false, but clearly misleading. And is it material? That's the question. You've got something that's misleading. So is it material? I think it's material because interest by other studios is a very important thing when we are looking at the alternatives Ari and his client have to making a deal with shady studios. Again, context matters, so the notion that that sentence is juxtaposed right next to the sentence about every major player having already expressed interest and I've got meetings, you put those two together, I think that looks worse than the two standing alone. I think what you would take away from this is that each of these statements is problematic, and when you put them all together, I think you probably have something that's pretty close to the line, perhaps over the line here. Let's take a look at the next scene.
Mallory, we're both busy people. Let's cut to the chase. Unless Shady Studios ponies up $4 million, which is my client's bottom line, we might as well end this conversation.
It's pretty clear what the ethics issue here is. Vitello's bottom line is $2 million, not the $4 million that Ari is representing to Mallory. What do we think about this one? If we can go back to Model Rule 4.1, it carves out estimates of price or value and suggests that those are not taken as statements of material fact. So if you only looked at Model Rule 4.1, and I doubt that many people would get that far, but even if they did, they would think they were in the clear. But then along comes an ABA Committee on Ethics that took a very detailed look at exactly this kind of question. In 2006, that committee issued ABA Ethics Opinion Number 06-439, which provides a lot of detailed guidance for lawyers engaged in negotiations. I should note that ABA ethics opinions are not directly binding on lawyers, but they will influence state bar committees whose job it is to apply their state's ethics rules, which, as noted, in almost all cases are based on the ABA model rules. Most of the guidance in ABA Ethics Opinion Number 06-439 appears sensible and consistent with how we have been looking at Model Rule 4.1 and the other ethics rules. But one part of the guidance that speaks directly to this part of our hypothetical is surprising. The opinion says, a party's actual bottom line or the settlement authority given to a lawyer is a material fact that a lawyer may not misrepresent in a negotiation. I think a lot of people were surprised by this because most lawyers don't actually believe one another when they hear another lawyer say, my client's bottom line is $4 million. Does anyone ever believe that? I think that would be the one statement by another lawyer that another person would be least likely to believe and therefore least likely to rely upon and least likely to be harmed by. Yet Ari's statement about his client's bottom line turns out to be precisely what the ABA ethics opinion prohibits. So that is puzzling. The opinion goes on to say, and this is important, that a lawyer may downplay a client's willingness to compromise or present a client's bargaining position without disclosing the client's bottom line position in an effort to reach a more favorable resolution. So it creates this distinction between my client's bottom line is $2 million or $4 million, as opposed to we'd never accept that little money to settle our claims. Applying the standards set out in ABA Ethics Opinion Number 06-439, Ari violated Model Rule 4.1 because his statement that Vitello's bottom line is $4 million, which Vitello had communicated to Ari that his bottom line was $2 million, was false. If he had said, "My client will never agree to take that little money for his script," or something else that merely downplayed Vitello's desire to make a deal, Ari would not have violated Model Rule 4.1. I would point out that even though Ari's statement about Vitello's bottom line is clearly false, I don't think it ever could give rise to a fraud claim because I don't think anyone could show reasonable reliance upon that type of statement. This example might cause you to think about different strategies lawyers might use when people try to engage us on what our bottom line authority is, since lying about it is expressly prohibited. One of the things we see lawyers doing now is not finding out what their client's bottom line is, because if you don't know what it is, you can't misrepresent it. The other thing we see lawyers doing is to refuse to engage in that conversation, claiming that it's privileged or simply deflecting the question. I find that it's often easier when somebody asks a question in a very pointed way, "What is your client's bottom line?" to ask the same question back. Usually they will respond with shock that you would ask such an inappropriate question, and of course it highlights how difficult the question actually is, and how it puts the lawyer in an unfair position. Usually the people asking that question aren't proposing that you trade that information. They would simply like for it to be coming their way. In addition to client bottom lines and settlement authority, ABA Ethics Opinion Number 06-439 provides a lot of detailed guidance for lawyers when we negotiate, so we need to review it in detail. The opinion starts by stating that it's not unusual in a negotiation for a party to make a statement in the course of communicating its position that is less than entirely forthcoming. I don't believe that is exactly a revelation. The question is, what does it mean that people are occasionally not entirely forthcoming? Does that mean that they are lying? Does that mean that lying is okay? Is this somehow recognizing that lying is inevitable or authorizing lying? This is a good place to make a distinction, and we're going to dip a little bit into negotiation theory here between what's called positional or distributive bargaining versus an interest-based bargaining. If you've had any kind of negotiation training before, you may have read Getting to Yes and other works by Roger Fisher and Bill Urey, who pioneered this field and who figured out that you can look at negotiations in one of two ways. Under the first approach, there's a certain fixed amount of stuff on the table, and if you're thinking of things from a positional or distributive perspective, it's all about getting as many of those things as possible. If there are 10 slices of pie on the table, how many of those 10 slices are you going to get, and how many of those is your opponent going to get? The second approach is what's called interest-based bargaining. The concept is that we can achieve more if we have a discussion about what you are really interested in, because the more I find out about what you're interested in, and the more you find out about what I'm interested in, there'll be opportunities to trade, things that you value highly that cost me little. And the notion would be that the sum of those things would mean that we both could win. It's not just a fixed pie with only 10 slices to fight over. It's like the orange where you only want the fruit and I only want the peel, and we both can get 100% of what we want. So when the ABA is saying, here are some things that you can misrepresent, including your alternatives, your interests, what your goals are, it really cuts against the notion that you want to have an interest-based bargaining, because interest-based bargaining is based on talking about what your interests are. If you're allowed to misrepresent those things, it really limits your ability to engage in a fulsome interest-based negotiation versus just, okay, there's 10 slices of pie and I'm going to try to get 7 of the 10. The best negotiators are always asking questions about the other side's interests. When they hear a position, you'll frequently hear a good negotiator say, "Tell me more about why you're asking for this thing. What are you trying to accomplish? What is important to you? What's the interest that you're trying to serve that explains why you're making that demand of us?" Getting more information about the other side's goals and their objectives is a critical way to come up with alternative ways to meet them. It's not always possible. It takes a lot of hard work and creative thinking, but in general I think that people dismiss that idea too quickly because it's hard work, and they're so focused on what's in the middle of the table that they don't think about other things that can be brought in, typically things that I may value less than you value. Those are perfect things to bring into the discussion. If I value something in a way that's lower than the way that you value it, now we can trade because there are probably similar things on the other side as well that you value less than I do. That's the classic win-win situation. Again, easy to talk about on paper. Those of you who've been doing this for a while can appreciate how difficult it is. But I think sometimes people use that as an excuse not to try. And in general, I've found that putting the time and effort into that very often bears fruit. But if I can lie about my interests and goals, if I can misrepresent my objectives, then we don't really get anywhere. It makes that process less useful, and it pushes you away from interest-based bargaining back to the distributive scenario. The opinion goes on and states directly that lawyers do not violate the model rules by misrepresenting, exaggerating, or downplaying several independent categories. They include a settlement position or a willingness to make concessions, a client's negotiation goals or objectives, the strengths or weaknesses of factual or legal positions, the value of the subject matter of the negotiations. That's similar to the price or value that we saw in Model Rule 4.1. And here's an important one: the lawyer's or the client's confidence in the availability of alternatives. This is the BATNA concept that I mentioned earlier. So we have a list of categories of statements that don't violate the model rules according to the ABA Ethics Committee. As a reminder, you have ABA Model Rule 4.1 that speaks most directly to lawyers when we negotiate, and it prohibits us from knowingly making false statements of material fact or law to a third person, or failing to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. This rule has a comment that helps us to interpret how these prohibitions are intended to apply in the unique content of negotiations, which sets out certain categories of statements that are not taken as statements of material fact, such as estimates of price or value. Finally, you have the ABA Ethics Committee interpreting both ABA Model Rule 4.1 and the comments such as to allow lawyers to misrepresent your client's alternatives, interests, and goals if you are doing so in the context of negotiations. Now we should ask ourselves, why would the ABA Ethics Committee say that misrepresentations in these categories do not violate the rules? Here is what the ABA says. Such remarks are often characterized as posturing or puffing, and are statements upon which parties to a negotiation ordinarily would not be expected justifiably to rely and must be distinguished from false statements of material fact. This is a real head-scratcher because these are the types of statements that I think people actually do rely upon. When somebody says, my goal here is to accomplish X or Y, I think that's the kind of statement that most people do rely upon. You might not take it to the bank and rely upon it to the point that you're going to seriously undermine your client's interests, but usually that's not something that you expect someone to be lying about. For example, when somebody is making a false statement about their alternatives, I don't understand, frankly, how the ABA committee can say that's not a false statement of material fact. And it's especially ironic given that the one category of statements that they seem to be so troubled by, statements about a bottom line or settlement authority, are exactly the kinds of statements that, at least in my experience, no one would rely on. I think there's a fair question here whether the committee got this exactly backwards. Whether we agree with the ABA ethics opinion or not, it is the key guidance in this area and will be used by state bar committees and courts in interpreting the model rules when judging the conduct of lawyers, so we need to understand it and do our best to follow it. Let's take a look at the next hypothetical.
Ari, hi. So sorry for the phone tag. I do want to get back to you on the Vitello deal, but we're so backlogged here with the Thirsty Games sequel as you could imagine. Let me call you after the holidays.
The ethical issue here is that Hinton is saying this merely to delay the negotiations so that Shady Studios can develop a competing script. 12 months later, when the script is done, Hinton ends the negotiations and interest in Vitello's script dries up after word is out that Shady Studios has its own script. I think that all of us hearing this have a certain gut-level reaction that this just seems wrong, and there has to be some ethical rule that prohibits it. But is that correct? The answer goes back to something we discussed earlier. There is no general duty to negotiate in good faith. We've set up this hypothetical so that there's no pre-existing contractual obligation to negotiate. It isn't a situation where this is the second script from Vitello and Shady Studios has an option to negotiate to buy that second script under the contract for the first script, where a duty to negotiate for that second script in good faith would be implied. So Mallory would appear to be in the clear here, but we need to mention three pretty big caveats. The first caveat is ABA Model Rule 4.4, which is entitled Respect for Third Persons, and says that in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. Is that rule triggered by this conduct? Possibly. I mean, this is certainly a delay tactic. It's a bad faith tactic, and it was done for the purpose of allowing shady studios to develop a competing script. When that competing script was complete, there's no interest in Vitello's script. I think you could argue that this is a delay tactic, so Model Rule 4.4 is possibly implicated. The second caveat is another provision governing lawyer conduct that I mentioned earlier, which is directly on point, but that isn't binding, not even on lawyers in California, where this guidance was issued. In 2007, the California State Bar issued a set of aspirational guidelines of civility and professionalism for lawyers. The guidelines include Section 18C, which provides that an attorney should avoid negotiating tactics that are abusive, that are not made in good faith, that threaten inappropriate legal action, that are not true, that set arbitrary deadlines, that are intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, or that do not accurately reflect the client's wishes or previous oral agreements. It's very clear that Mallory violated a couple of those clauses, most notably gaining an unfair advantage, which is what happened here. But the guidelines are only aspirational, and no lawyer, not even lawyers who practice in California, can be subjected to an ethics complaint for having violated any of these guidelines, including Section 18 dealing with negotiations. So while the guidelines reflect how the California State Bar thinks lawyers should behave when we negotiate, as we saw before when I clarified that there is no general duty to negotiate in good faith, the aspirational, non-binding guidelines differ from the law and the legal ethics rules that actually govern lawyers when we negotiate. The law of fraud, plus the legal ethics rules and related formal ethics opinions and court decisions, collectively comprise the standards that actually govern lawyers when we negotiate, and it is those binding rules and those rules alone that can subject lawyers to adverse consequences if they fail to follow them in terms of potential civil liability and potential sanctions under the legal ethics rules. For this reason, I'm not a big fan of the guidelines, including Section 18, because they serve to muddy the waters between what conduct lawyers can engage in when we negotiate and what we cannot, by virtue of layering on vague, additional, and non-binding guidance on which reasonable lawyers might disagree in terms of its application to any particular set of facts. While the law of fraud and the legal ethics rules are not always a perfect fit for governing the conduct of lawyers when we negotiate, as we will see in some of our later hypotheticals, the existing law and the legal ethics rules do a pretty good job. The last thing we need is another set of rules to create confusion in an area that is already confusing enough because of the many different tactics lawyers can use in negotiations. Within the outer bounds established by the law of fraud and the legal ethics rules, lawyers should be allowed to negotiate as they see fit. I don't mean to suggest that lawyers should use dirty tricks or engage in other sharp practice when we negotiate, even if the particular tactic doesn't violate the law or the legal ethics rules, because I think that lawyers who do that suffer damage to their reputations that actually make it harder, not easier, for them to achieve the best results for their clients in negotiations. I think that lawyers can and should make up their own minds how they choose to negotiate, taking into account the law, the legal ethics rules, and potential reputational consequences, and that we don't need Section 18 of the guidelines to make sure that we act as professionals. In addition, in my opinion, we don't need Section 18 to help us deal with lawyers who use dirty tricks or engage in other sharp practice in negotiations, because we lawyers are perfectly capable of dealing with those tactics ourselves, provided that you've had a little training in this area. Besides, there is no judge or state bar official present in your negotiations, so even if you could show that the other side's conduct violates Section 18 or even the law or the legal ethics rules, you can't appeal to anyone in the moment to take action on your behalf anyway. Indeed, I've devoted considerable time in each of our Negotiation Ethics for Lawyers programs to teaching lawyers techniques they can use to counter dirty tricks when the other side attempts to use them on you. You can do this very effectively and without violating the law or the legal ethics rules yourself once you are able to spot the dirty trick and have had some training on how you might respond. While we are focused today on the ABA model rules, which nearly all states have adopted in some form or another, including just a few years ago California, our discussion wouldn't be complete if I didn't make a couple of comments about the legal and ethical standards that apply to California lawyers when we negotiate. I'm not talking about the California State Bar's civility guidelines that we just discussed at some length, which, as I noted, are not binding. I am talking now about binding California statutes. While California follows the ABA model rules, California has on its books 3 statutes that predate its adoption of the ABA model rules that could be read to impose greater obligations on California lawyers than we find under the model rules. The first statute is California Business and Professions Code Section 6068, which requires, among other things, that an attorney employ, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth. The second statute is Business and Professions Code, Section 6106, which states that, quote, the commission of any act involving moral turpitude, dishonesty, or corruption, whether the act is committed in the course of his relations as an attorney or otherwise, and whether the act is a felony or misdemeanor or not, constitutes a cause for disbarment or suspension. The third statute is Business and Professions Code Section 6128A, providing that every attorney is guilty of a misdemeanor who is guilty of any deceit or collusion, or consents to any deceit or collusion with intent to deceive the court or any party. The additional caution for California attorneys is that while you have the ABA Ethics Committee saying that you don't violate Model Rule 4.1 by making false statements about your estimate of price or value or your intentions as to an acceptable settlement of a claim. For example, you have statutes in California saying attorneys may employ those means only as are consistent with truth and expressly prohibiting them from engaging in dishonesty or deceit. While I believe the California State Bar and its courts would look at the guidance promulgated by the ABA when judging the conduct of lawyers when we negotiate, particularly now that California has adopted the ABA model rules, you should be aware that these other statutes exist where the language is admittedly vague, but also pretty absolute, in requiring attorneys to employ those means only as are consistent with truth. You can add to that the non-binding civility guidelines issued for California attorneys we just reviewed as additional reasons to be cautious about taking sharp edges in negotiations if you are licensed in California. The third caveat for Mallory in this example is the possibility that her conduct will cause her client to catch a fraud claim. Is there any fraud here? Whether there is fraud or not, I think it very likely that if Shady Studios played this type of a game, Vitello would be very likely to bring a fraud claim. You're negotiating for something that you were trying to get $4 million for and were willing to take $2 million, and now it's worth zero. I'm sure you could comb through the negotiation record and find a false statement here or there, and you'd certainly find detrimental reliance. Something along the lines of, I was negotiating with you and not exploring all these other opportunities I had. And of course I was damaged by that. My value has gone to zero. While Shady Studios certainly could contest whether Vitello's reliance was reasonable, as many experienced negotiators would say that nothing short of an actual signed deal is reasonable to rely upon, and that if Vitello was waiting during the process of the negotiation, then he waited at his own peril. The fact that Shady Studios used the time to develop its own competing script makes them look like a bad actor, and we know that courts and juries tend to find ways to punish people who behave badly. At the end of the day, I think you'd be looking at a fraud claim, even if you probably don't have an ethics violation here, just because of the limitations of the rules. So now let's take a look at the next scene.
Both Universal and Paramount Pictures have offered us $3 million. Can Shady Studios top that?
The ethical issue here is that Universal has made an offer of only $1 million and Paramount has made no offer at all. This one is pretty easy in terms of whether it's an ethical violation. It's a straight misrepresentation and it's plainly material. I think that it is in a way the most damaging kind of misrepresentation because it is the false alternative, or sometimes called the false BATNA. And if negotiation is about leverage, and leverage is all about having good, reasonable, viable alternatives, if a party doesn't have those kinds of alternatives and all they need to do is fabricate them, then we are living in a world in which people are able to create leverage out of nothing, and it's difficult to rely upon statements. What's interesting is that this could be done with alternative language that maybe doesn't cross the line quite so clearly. Let's take a look at that example.
I've spoken with both Universal and Paramount, and I'm very confident each will offer us $3 million. Can Shady Studios top that?
In this case, Ari comes back by saying, I've spoken with both Universal and Paramount, and I'm very confident each will offer us $3 million. Can Shady Studios top that? You may remember that when we looked at the ABA Ethics Opinion number 06-439, there was a category of statements that were accepted from ethical violations, and it had to do with overstating one's confidence in the availability of alternatives. And the question, of course, is this covered? The problem that I see here is that it's preceded by this statement about having spoken with both Universal and Paramount. It's in the very same sentence and it's tied together with the confidence and the alternatives. So another way of looking at the question is, even though one can say, I expect and I'm confident that we're going to receive offers, and even identify a range, does it somehow cross the line when you precede that statement by saying, I have spoken with Universal and Paramount and I am confident? Clearly, the reason for saying I've spoken with these studios and identifying them specifically is to try to create the idea in the other party's head that those parties have made statements to the effect that they are going to be offering $3 million. I think this one is pretty close to the line. One might say that talking about being confident in certain things happening is just a prediction, or it's a statement of opinion, and therefore it doesn't create any ethical issues. I think here that when you connect the claim that you've spoken with these studios and your claim that you are confident they will make an offer, that may cross the line. Personally, I wouldn't go that far in a negotiation that I was handling, but I think we could have a spirited discussion about whether Ari's statements here are enough to constitute an ethics violation. Another key takeaway is how should you respond when the other side makes statements to you in a negotiation, similar to the ones Ari makes to Mallory here. First of all, being a good negotiator depends in large part on paying very close attention to what's being said, what isn't being said, and asking good questions. So clearly you could say, oh, that's interesting. You're very confident. Well, has anyone already made an offer? Also, when somebody starts using these weasel words that are making it clear that they have not received the offer, but they're very confident, it gives you a lot of information. The next time somebody tells you in a negotiation that they're very confident that they're going to receive a competing offer, try saying, well, where is it? And why can't you share it with me? That tends to work pretty well to cut through a lot of the posturing and misdirection. Let's take a look at the next hypothetical.
Ari, let's be real here. Visionary Pictures, the only bidder offering more than us, is on the verge of bankruptcy. Trust me, I have a friend there who gives me the real scoop. So that really leaves you with no interest for Vitello's script.
Let's focus on what Mallory's saying here. Ari, let's be real. Visionary Pictures, the only bidder offering more than us, is on the verge of bankruptcy. Trust me, I have a friend there who gives me the real scoop. So that really leaves you with no interest for Vitello's script. The ethical issue is that Mallory doesn't have any inside information and she's just going on what she reads in the paper, the same as everyone else. The key question here is this a statement of fact or is it just Mallory's opinion? The statement, Visionary Pictures is on the verge of bankruptcy. I think it probably best understood to be an opinion. Aside from the few people at Visionary Pictures who would be in a position to know whether the company is about to make a bankruptcy filing or not, everyone else simply would have an opinion about it. Mallory makes it worse by dressing it up with the pretense that she has some inside information that the rest of the world doesn't have, so that could be a cause for concern. But on balance, I think it's probably more likely to be judged an opinion. Maybe a false opinion or Mallory's true opinion than a false statement of fact. While we're not here today to talk about negotiation strategy or tactics, it is worth noting that this example illustrates another important point about leverage in negotiations. We talked about the idea of alternatives, and your BATNA the best alternative to negotiating an agreement with the other party. And the best negotiators understand that alternatives can work in both directions. As a negotiating party, you're thinking about what your own alternatives are, but you're also thinking about the other party's alternatives. So here we have a statement, not about one's own BATNA, but about the other party's BATNA. At the same time that this negotiating party's attempting to build up their own BATNA and therefore acquire more leverage, they're trying to beat down the other side's BATNA in order to suggest that they know that they don't have much leverage at all. That's one reason why telling lies that relate to alternatives, either your alternatives or the alternatives available to the other side, can get you into trouble very quickly because those statements are almost always material to the negotiation. Let's take a look at the last hypothetical.
Ari, you're a no-name agent, and I represent one of the biggest media conglomerates in the world. It's time to accept our offer and stop trying to play with the big boys. If not, I'll make sure everyone in this town knows what a joke you are. Plus, I'm sure your former mob boss client would enjoy hearing how you screwed up this deal.
Here we have some bullying on the part of Mallory, essentially saying you'll never do business in this town again, and I'm also going to tell your former mob boss client how badly you mishandled his deal, clearly making a threat. This returns to a familiar theme of bad faith negotiating. Can you be a bully? And is that permissible or not? While there is no general duty to negotiate in good faith, the more important thing here is, would it ever be a good idea to say anything remotely like this? In any litigation between Vitello and Shady Studios, Mallory's words are going to be exhibits A, B, C, all the way to Z. These are bad facts that the other side is going to put on the table that are going to make you look terrible, even if this isn't an ethical violation, which it probably isn't based on the rules we've been discussing. Another key thing to observe is that even if Mallory takes no action at all in response, she doesn't call anybody, doesn't try to in any way interfere with Ari's business prospects, she's very likely to get a claim from Ari, right? Anything that happens where Ari doesn't get some deal done, there'll always be the possibility that Mallory had interfered and the risk of a tortious interference with contract claim. Really just a bad idea in general to be a bully in this way in negotiation. A lot of people think that bullies can be very effective in negotiating, but I think the collateral damage that they cause often is much worse, and their effectiveness is really not as great as they tend to think it is. It's time now for a summary of what we've covered today. We've seen in the course of today's presentation the general rules that require lawyers to be candid in their dealings with others. That's ABA Model Rule 8.4, as well as the general rules that require lawyers to be zealous advocates, such as Model Rule 1.3. And we've discussed a fair amount today about just how zealous can you be and still stay within the bounds of these ethics rules. And in general, you are not required to press for every advantage. You certainly can be reasonable in negotiating. You can take an interest-based approach to negotiating, which many top negotiators, myself included, recommend. And you're not required to fight over every last dollar. But there are certain pretty clear bounds that you still have to stay within. And that's really bounded by these rules, and then, to a lesser extent, the ethics opinions that help to interpret the rules, but they themselves are not binding. I also cautioned you, particularly those of you who practice in California, about some statutes that exist and are binding, and that contains some pretty sweeping language that bars attorneys from being dishonest, that could trip you up, even when other authorities like ABA Ethics Opinion Number 06-439 suggest that certain conduct in the context of a negotiation would be okay. When we started today, negotiation ethics sounded like a pretty nebulous term, but we have ended with some pretty specific takeaways. Clearly, you may not misrepresent your bottom line or the settlement authority that you have been given. We talked about how to deal with issues surrounding your bottom line or your authority. We talked about asking the other side what their authority is or what their bottom line is. We talked about ignoring the question. We talked about claiming privilege or otherwise dealing with it. But clearly, as a lawyer, you may not misrepresent your bottom line. Better to speak of your client's inclination toward a potential agreement and not his or her bottom line. What else have we learned that is clear in this area? The rules do not expressly bar attorneys from misrepresenting facts or law if they are not material. We learned that that word material is going to be critical in terms of whether there's a violation. The rules also don't prevent attorneys from misrepresenting opinions or intentions or state of mind. Those are other categories of things that if you're negotiating with someone and they're making statements about their state of mind or their intentions or their opinion, you want to be thinking about the fact that those may not be true. And in fact, if they're not true, it's not going to create an ethical problem for the other side. The rules do not preclude lawyers from misrepresenting their settlement positions. Different from bottom line, but their settlement positions clearly can be misrepresented. You want to be very careful when hearing statements like that. And that also includes statements about that side's willingness to make concessions. If you hear an attorney claim that their client is not willing to make any concessions, you can hear that and know that it is not going to be an ethical violation, and it very well may be misrepresented. Lastly, there is sort of a catch-all. Lawyers are not precluded by the rules for making misrepresentations that are not knowingly false, which is the language of ABA Model Rule 4.1. And you can be quite certain that if an opposing attorney makes a statement of fact to you that turns out to be false, that they will claim that it was not done knowingly. Finally, this brings us back to ABA Formal Ethics Opinion number 06-439, which says that the lawyer you are opposing may, without violating the ethical rules, misrepresent his or her client's goals, the client's objectives, or the strengths and weaknesses in the client's position. The value of the subject matter may also be misrepresented to you, and the lawyers you're facing may also misrepresent their confidence in the availability of alternatives. With all of that said, you also should not forget that apart from the legal ethics rules, there is the law of fraud that would allow the other party to make a claim in cases where the lawyer on the other side in a negotiation made false statements that were material, and upon which the other party relied to their detriment and suffered damages. Accordingly, it is important to remember that there is a big distinction between statements about material facts, which cannot be misrepresented under the legal ethics rules and the law of fraud, and statements about your client's goals and objectives, or about your confidence in your client's alternatives that you may be able to misrepresent under the legal ethics rules as interpreted by ABA Formal Ethics Opinion number 06-439 and some of the commentary to those rules that we have discussed today. But of course, there are other takeaways that we'd like you to have, not simply where the rules of ethics draw lines, but more practical advice about listening very carefully to the representations that are made to you, asking follow-up questions, always pushing and pushing to clarify statements that are made, asking questions to try to discover the other side's interest. All of those things are going to help you avoid being deceived when misrepresentations are being made to you. This gets us back to ABA Ethics Opinion number 06-439, which is the most direct treatment of the question that we're talking about today: what ethical rules apply in negotiations? That opinion says that the lawyer you are opposing may, without violating the ethical rules, misrepresent that client's goals, their objectives, the strengths and weaknesses in their client's position. The value of the subject matter may also be misrepresented to you and the parties that you're facing. The lawyers you're facing may also misrepresent their confidence in the availability of alternatives. And again, you want to listen very carefully to the language that they're choosing. When thinking about BATNAs, always remember you are not the only party that has a BATNA. So if you spend all of your time trying to figure out what your alternatives are, you'll be doing exactly half of the analysis that you need to do. You also need to think about your opponent's best alternative to a negotiated agreement. I hope I've convinced at least a few of you that negotiation ethics for lawyers is not a complete oxymoron. There are rules. They are specific. It is possible to make informed judgment calls about these matters. And frankly, that the best practice is not to be looking for exceptions and looking for ways to exploit the exceptions. The best practice in general, to meet one's obligation of competent advocacy and your duties of candor, are to take the same steps that you would take as a matter of simple common sense. You will be much more effective and much more competent in your representation if you are following the rules in that way, especially over the long run. I also think it refutes the notion that lawyer negotiators are in any way limited because the way you should negotiate. Avoiding sharp practice out of concerns about reputational consequences and potential legal claims is just really good advice for everyone, not just lawyers. And this advice happens to dovetail nicely with what the legal ethics rules require of lawyers when we negotiate. Finally, to the extent that you're negotiating a deal on behalf of a client, Presumably, the goal is not to reach any deal. The goal is to reach a durable and enforceable deal, and your client is not going to be well served by engaging in conduct that, if it's discovered later, threatens the durability or the enforceability of the deal that you've reached. The client wants to be done with you and your legal fees the minute the deal is done, and they don't want to face the risk of a lawsuit for rescission or fraud or anything else. The fact that you're being ethical as a lawyer really just falls in line with how you should behave generally, both to preserve your professional reputation and to best serve your client's interests. I hope you enjoyed today's program, and thanks very much for joining me.